YouTube, then we'll get this thing going. So
Cool.
it usually takes about 20 seconds or so. All right. All right. YouTube's going and Facebook's going. So, all right, everyone, welcome. This is kind of like a bonus episode for Build with the CEO. And so Matt reached out to me and kind of wanted to kind of update our crowd on what's been going on. And we're going to keep this specific to the click to cancel. This has kind of been the saga of the fitness industry for the past probably 6 to 9 months of how you have to make it as easy to cancel as it is to sign up. And so, I mean, we hear lots of stuff coming from lots of different places. And so I think it's good to talk to someone that is really in the know. And just so for people that don't know your background, Matt, just give us your quick background.
Yeah. Thanks, Trevor. And thanks for having me on for the bonus episode.
Absolutely.
I didn't think I realized that. So cool. I'm the owner and lead attorney of Gym Lawyers, PLLC. We're the leading legal consulting and advising firm for sort of the gym industry, I'll say generally, across the U.S. And that covers whether you're brick and mortar, whether you're online, you're doing pickleball or yoga, Pilates, CrossFit, cheerleading, gymnastics, like anything. I guess I should say the fitness industry more than the gym industry. But
right.
That's pretty much what we do.
So bring me up to speed on the click to cancel stuff. I mean, we can kind of go to where it started, what the goal of it was, and then kind of like bring us up to date on where we're at today.
Yeah. I mean, for anybody listening, we can string them out, okay, and force them to listen till the end to get the juicy stuff. But the bottom line is we don't have to worry about it anymore at the immediate moment. So, quick review: back in October, the FTC dropped a rule. So the Federal Trade Commission dropped a rule saying that anybody who's offering a subscription-based service has to make it as easy for somebody to click as it was, or to cancel as it was for them to sign up. You hit that summary pretty well a moment ago. And so, if I'm selling an online service and I can go through your website and I can click, I want to pay $25 a month for your online programming, and I click boom, and I put in my credit card information. Now I have access to the app. I need to be able to basically like go through the app and click a button to cancel instead of emailing you in order to get it canceled, etc. Okay. So that was like the basics. It was never designed to hit the fitness industry. It was just always meant to like, other online services, other subscription-based programs. I kind of like pick on Netflix every so often on these things because like that's what it was designed to do.
Right.
It just hit us because of the subscription-based models that almost every gym uses anymore. So it comes out in October. It then gets filed in what's called the Federal Registrar's Office in about 30 days. And then from there, we basically all get like 9 months to attack this thing. In January, it technically went into force into law. And then in May, it was supposed to go into enforcement. It then got jumped back to July for enforcement purposes. So for the last, like you said, last 6, 7, 8 months, we've all been like, what does this mean for the gym industry? What are we going to have to change? Before we got on, you were talking about client management softwares and how they were like spinning their wheels trying to make sure that they were going to be compliant. And then part of what happens within that 8-month, 9-month period is it gives essentially the consumers or consumer related businesses the opportunity to fight back, okay, to challenge the rule, to essentially sue the FTC in some sort of alleged violation, to say like you violated the procedures in installing this rule, or the rules, the language is incorrect, or it's unconstitutional, or something like that, in order to strike it down. Sure enough, we got to like 2 or 3 days before this thing was supposed to go into enforceability this month, and a federal appeals court said, you know what, there was an issue with the way that you guys tried to implement this rule. So we're striking the whole thing down at this point.
So what does that typically mean then? Like if it was simply like, hey, you didn't follow the correct procedure in order to make this happen, that doesn't necessarily mean that something goes away. It just means that like, okay, we have to restart the process.
Yeah, essentially, yes, they have to restart the process if they want to do it. And I'm sure there's going to be a lot of talk back and forth, a lot of political pulling strings and things, because even up to the point that the federal appeals court struck it down, this thing went into play prior to the current administration. Well, there was a lot of talk out there that once the current administration went in, if they got, if whatever they were doing in the changes in the government trickled down to this rule, it was going to get overturned anyway. And so the second in command at the time that the FTC rule came into play back in October, the second in command at the FTC did not like this rule. The head of the FTC did, so it continued to move in. But then there were all kinds of rumors that said, well, the current administration was going to get rid of the current head of the FTC, appoint the second in command who would have just killed this rule to begin with. So the ability now for the FTC to turn around and bring this rule back up, they're automatically going to have to jump through some political hoops to even get it back on the table of consideration. And then the whole reason that it got struck down was because they failed. It was the the public regulatory analysis or something, preliminary regulatory analysis was sort of like the buzzwords of why this thing got struck down, because the court said the FTC did not complete this regulatory analysis prior to dropping the rule. What that basically means is because this thing was projected to have an impact of more than $100 million per year, they had to jump through a whole bunch of other analysis hoops before they put the rule into place, looking at alternatives, why the rule was necessary, outlining the rule's objectives, demonstrating how it was really going to protect consumers. And they just kind of skirted that analysis according to this appeals court.
So what, I mean, from your standpoint, like what do you see, or how are you advising the different gyms and coaches that you work with?
Yeah. So at the immediate moment, like, don't make any changes. I mean, we should still look at, and I know we're going to get sort of away from the federal here in just a moment, but we should still look at your processes just to make sure that like they're decent processes, right? They are compliant, but the bottom line is if you want to let somebody sign up on your website now, but you don't want to force them to email you, or if you own a brick and mortar, come into your gym or fill out a cancellation form or something like that, which is all like this gray area around the click to cancel. We don't have to worry about that gray area anymore. You can do it.
Right.
So you don't necessarily have to change your process.
Right. But you did mention that there are some states that are kind of doing some regulatory stuff. And so,
right.
I mean, do you have that do you know that list of states off the top of your head, or like, do you have a list of some of the major ones that you remember?
Yeah, so there's, I would think it's Iowa did this a couple years ago. California basically like copy and pasted and then added some extras to their own click to cancel rule. And I think that went into enforcement at the beginning of this month.
Okay.
So all gyms in California now, even though the federal FTC the federal click to cancel got essentially denied, California's is still in force. So if you're a California gym, or even if you're operating an online practice out of California, there's some gray area there. You really need to know.
So when you say an online, like your business address is inside of California, even though you may be coaching people in Florida, Texas, that kind of thing?
That's right. Yep. Okay. Yep. Yeah. And where they kind of get you there, I'll get over into those weeds just a little bit here. So whenever we're doing an online business, I don't really think you and I, Trevor, have ever really gone down this route, but whenever we're doing an online business, we need some sort of like membership agreement or recurring nature, recurring authorization to take some kind of recurring payments. And you probably want some sort of liability waiver. Within those two legal contracts, you're going to have a whole list of what are called miscellaneous contract terms. One of those miscellaneous contract terms is what law governs this agreement. What is the proper venue if somebody wants to sue you over the waiver, if somebody wants to sue you over your recurring payment agreement? Where does this have to happen? And so if you ever look at like really big companies, like if you pull out like your cell phone and you find that section, it's going to say something like Delaware is the state and the venue that will apply. So if you ever want to sue your cell phone company, you have to go to Delaware to do that. All right. All of this is to say, when we're doing online businesses, we have to have in our agreement what state's laws apply and what state is the proper venue. This is advantageous for somebody doing online because if I'm in California and I'm providing programming to somebody in New York and they want to sue me for something going on in my programming, They're probably not going to come to California to do so because the contract says they have to. So it's a layer of protection for the coach providing virtual training services. All right. Now, back to how this is relevant. If we're operating a business out of California that is servicing across the US, but we have to set the jurisdiction and venue in California, now we have to make sure that we're actually following California laws, which means we now have to be concerned about whether or not the click to cancel rules are applying to the type of work from California that we're providing.
So if, I mean, let's just use California as an example. And so if a coach has like a website where someone clicks through, maybe it takes them to like a Stripe checkout page or something like that to agree to a coaching relationship, essentially, right? By how it's written, they would then need to be able to, from the app, from the website, be able to cancel said registration or said subscription as well without necessarily talking to someone.
And it's very basic, yes. That is what it is designed to do. California has a couple of other caveats. And so don't quote me on it because I don't have the language of the statute right in front of me. But my recollection last time I reviewed it, and it's long, is if you allow people to sign up online via phone, via email, or in person, you can then provide them all those different options to cancel as well. Okay. So if you allow somebody to sign up via phone, then you can allow somebody to cancel via phone, even if that's not necessarily the way that they signed up. So there is some nuance in there within the California's rule, but just understand it. Its basic idea is that it has to be as easy to cancel as it was for them to sign up. And if you're in California, you really need to make sure that your process is following this. Right. New York changed some laws, but doesn't really impact. They changed the laws regarding cancellation if they cancel within a certain amount of time after signing up. It's called a consumer's rights or buyer's remorse clause. Yep. So all that says is like, if I sign up, most states have this, within like 3 days, 5 days, 7 days, you have to allow me the automatic right to cancel with full refund. New York adjusted some of the time periods around that. So that was another one. And then there's another Midwest state, Montana, Missouri, one of those. I can't remember off the top of my head, but they pretty much have a full in effect click to cancel rule as well.
Okay. And so for Stripe has what a customer is created inside of Stripe, right? They have like basically the customer can log into their back end and potentially cancel their subscription from that point. Does that seem to be sufficient for them to be able to do that? Or is it literally like a button needs to be somewhere? You know what I mean? Like if you were looking at that, how would you feel like
I would say that would be fine. Yeah. I would say that would be fine. It doesn't have to be like, if I can sign up on the website, right? Like I can go through the website, I fill out my form, I put my credit card information. And like you said, it's just sort of like I pulled in Stripe and put it on my website in order to do that. You don't have to provide me the ability to then cancel it on the website. I've created, because I've signed up, I've now created some sort of client profile within Stripe. So all I have to do is be able to go into that client profile and then cancel. And
And this is only for subscriptions, right? If I sell a $400 challenge that lasts, like let's say someone pays in full up front. Like let's say there's a 6-month coaching program. They pay $5,000 up front. Right. Even though it's over the course of 6 months, does this still kind of apply, or is it different when it's a lump sum one-time payment thing?
That's a super intelligent question, because it's one that we see more with virtual training services than we see with brick and mortar services. And so the idea is, if you put a term on your membership, if you put a term on the service that you're offering, you do not have to comply with click to cancel.
So it's really for just like month to month or open-ended type of subscriptions.
That's right. Some states are making a distinction between, I forget what it is, automatic recurring payment versus continuous payments. And I've read it like 5 times and I'm not sure I fully understand what automatic recurring payments versus continuing payments, what the difference is here, even with the legal definition. But I think that's where some states are looking at this and saying, well, if you do a 12-month and you take monthly installment payments, that's like that's just continuous payments through the term versus automatically renewing in perpetuity. Right. So there is a little bit of nuance there, but for FTC purposes, no. And we started to have that conversation with gym owners of like, well, just set a 12-month term to your contract. Right. And at the end of that 12 months, just sell them into another 12 months. And we don't have to worry about any of this.
Right. Yeah.
And we see that a lot with virtual services.
Yeah. Virtual. I mean, there's for a time period, it's starting to change a little bit, but there used to be a lot of like paid in full upfront type of thing. But in the gym world, I mean, we kind of saw the transition. There's still a lot of like 12-month contracts, but then they typically auto renew into a month-to-month or something like that. Right. Just because having to resell people, right, is a headache, and B, you're going to lose some people that way too. And so, okay, well, that's really interesting. I mean, this is good. I mean, this is good to know. And so probably like the people would be good for another 6 months, a year. Like this stuff doesn't, in your experience with watching other things that go through this process, like they don't just come pop back up in the next month. It's like, it's a long process.
It's a very long process just to create the rule period. So take that into account. If they're going to redo this, they have to start over. They got to completely redo the rule. Then they're going to have to do that market analysis that the court said no. Then they're going to have to get it past all of the people within the FTC to actually get this thing to come down into another rule. Right. Then we start back over with, okay, the Federal Registrar's Office now has to file it. Once it gets filed, now everybody has 9 months in order to sue over this thing. So it'll be at least a year, right, if not more, before we ever see the light of day on this thing again.
Cool. I like it. And I mean, to be honest, like when we look at this with coaches, a lot of coaches are good people and they have good they have good processes in place. They're not, we see this a lot with like this was notorious in like the 24-hour gym world, like in like the early 2000s, like you could sign up really easily, but then you need to like come in. Have you seen that Friends episode where like the guy comes in and tries to quit the gym?
I'm sure I have, but I haven't watched
it. It's kind of like what it is. Like you come in, I want to stop my membership. Oh, let's have you meet with our manager here quick and go through that process. And so I think there's good pieces of it, but I think if people are being decent human beings and have a good process in place, like you're probably going to be all right. But it's good stuff to at least pay attention to. So I appreciate
I think that's why it got like such a bad rep in our industry, is because it was like, this doesn't even apply to us. Yeah. Like we're not trying to lock people into these agreements 9 times out of 10. Yeah. We see that. Like I saw it once with a franchise. My wife was doing some franchise gym in California and they were like, you have to come in to cancel. And I was like, hold on a second.
I know a guy that may have some information on this.
So they do exist, but you're right. For the majority of the people that you and I both work with, like this just made a headache. It wasn't necessary. It was just a headache. So we don't have to worry about it now.
All right, Matt. Well, I appreciate you coming on, man, and just kind of giving us the down low on where we're at with this thing. And I guess hopefully we kick the can down the road and don't have to worry about it for a little while.
Anytime at all. Always happy to hop on and chat.
All right, brother. Thanks.
See ya.